Your offshore employer has a nightmare scenario. It's a moment an injured worker discovers they're not stuck with workers' compensation. The moment they learn about the Jones Act. Because when offshore workers understand their real rights under the maritime law, those $75,000 worker comp settlements suddenly become $2 million Jones Act cases. I'm maritime injury attorney Matt Schaefer, and in this video, I'm going to reveal 5 things your offshore employer desperately hopes you never figure out about the Jones Act. Because each one of these secrets could be worth hundreds of thousands of dollars to you if you're ever injured on the job. Let's start with the big one. Secret number 1. You have the right to sue your employer for negligence. Under workers' compensation, it doesn't matter if your employer did something stupid or dangerous that caused your injury. Workers' comp is a no-fault system. Your employer pays a set amount, and you can't sue them no matter how badly they screw up. But if you're a Jones Act seaman, you can sue your employer for negligence. And here's the key. The legal standard is slight negligence. Your employer doesn't have to be grossly negligent. There has to be a little bit carelessness proven. What counts as slight negligence? More than you might think. Not replacing worn equipment when they should have. Using defective gear. Failing to provide proper safety training. Rushing jobs to meet deadlines. Poor maintenance. Unsafe work procedures. I've won cases where the only negligence was an employer failed to inspect a cable that should have been checked monthly instead of quarterly. That slight negligence and was worth a win of $1.8 million. Your employer knows this. That's why their safety officers show up at the hospital after you're injured with paperwork claiming the accident was your fault or an act of God. They're trying to create a record that protects them from negligence claim. Here's secret number 2. You can choose your own doctor. Workers' comp gives the insurance company control over your medical care. They pick your doctors. They approve your treatment. They decide when you're recovered. They decide when you're ready to go back to work. And guess what? Those company doctors work for the insurance company, not for you. Their job is to get you back to work as quickly as possible, not to make sure you're fully healed. Under the Jones Act, you control your medical care. You pick your doctors. You get the treatment you need. If you want a second opinion, you get one. You can go to a doctor who will actually look out for your interests. This just isn't about getting better medical care. It's about compensation. Independent doctors are more likely to accurately document the full extent of your injuries and limitation. Company doctors tend to minimize everything. I had a case where the company doctor said a worker's back injury was minor and he could return to work with no restrictions. The worker's own doctor found a herniated disc that requires surgery and permanent lifting restrictions. That difference in the medical opinion was worth over $800,000 in additional settlement value. There's a third secret. There are no caps on compensation. Workers' comp uses scheduled benefits. Lost an arm, here's your set amount. Back injury, here's what the chart says. Those amounts are usually insultingly low and don't account for your individual circumstances. The Jones Act has no caps. Your compensation is based on your actual damages, your actual medical bills, including future treatment, your actual lost wages, including future earning capacity, your actual pain and suffering, the actual impact on your family. That means a back injury that gives you $75,000 under workers' comp might be worth over $2 million under the Jones Act if it ends your career and causes chronic pain for the rest of your life. Age makes a huge difference too. If you're 28 and suffer a career-ending injury, your lost earning capacity over 35 plus years could be worth millions. If you're 58 with the same injury, your lost earning capacity might be only worth a few $100,000. Workers' comp doesn't care about your age. The Jones Act does, and that means the difference between a small settlement and a life-changing amount of money. You're also protected from retaliation. The biggest fear I always hear from prospective new clients is that they're going to get blackballed or blacklisted from the industry for filing a claim. Don't rock the boat. Don't be known as the guy who sued. You'll never work offshore again. This fear keeps injured workers from pursuing their legal rights, and their employers count on it. But here's what they don't want you to know. The Jones Act makes retaliation illegal. If your employer fires you, demotes you, transfers you, or otherwise punishes you for filing a Jones Act claim, that's a separate federal claim. And if you can prove retaliation, you can get additional damages. I've won cases where the retaliation damages were worth more than the original injury claim. Most importantly, offshore workers can't afford to blacklist people in today's labor market. Good offshore workers are hard to find. Companies need experienced hands. They're not going to pass up qualified workers because they exercised their legal rights at a previous job. The retaliation threat is mostly a bluff designed from keeping you from asserting your rights. And here's the last secret. You most likely have multiple claims, not just one. Most injured offshore workers think they have one claim, either workers' comp or Jones Act. But Jones Act seamen often have multiple claims that each stack on top of each other. First, you might have both a Jones Act negligence claim and an unseaworthiness claim. Unseaworthiness means the vessel or its equipment wasn't fit for its intended use. You don't have to prove negligence for an unseaworthiness claim, just that something was defective or inappropriate for the conditions. For example, if a crane cable snaps because it's worn out, that's a both employer's negligence, they should have replaced it, and unseaworthiness. The cable wasn't fit for its intended purpose. Second, you might have third-party claims. If your injury was caused by a defective equipment made by another company, you can sue both your employer under maritime law and the equipment manufacturer under product liability law. Third, you're entitled to maintenance and cure regardless of fault. Even if your injury was 100% your fault, even if you violated safety rules, your employer still owes you living expenses and your medical bills paid until you reach maximum medical improvement. But maintenance should cover your actual living expenses. If your mortgage, utilities, and food cost $4,000 a month, that's what your maintenance rate should be. I've had cases where fixing the maintenance and cure alone added $50,000 to $100,000 to the settlement value. Here's why your employer doesn't want you to know these things. Knowledge is expensive for them. An offshore worker who doesn't know about the Jones Act might accept a $100,000 workers' comp settlement. The same worker who understands the Jones Act may pursue a $2 million claim. That's why companies send safety officers to the hospital with incident reports for you to sign. They want you to admit fault before you understand your rights. That's why they immediately start the workers' comp process and act like it's the only option. That's why they pressure you to accept quick settlement offers before you've had time to understand what your case is really worth. They're hoping you don't know what you don't know. Now you do know. And if you work offshore and you're injured, you don't have to accept what your employer tells you. You have rights under the federal maritime law that are worth significantly more than workers' compensation. You have the right to sue for negligence under a favorable legal standard. You have the right to control your own medical care. You have the right to compensation with no artificial caps. You have protection from retaliation, and you probably have multiple claims that add up to serious money. The key is understanding these rights before you sign anything, before you make statements to insurance adjusters, and before you accept any settlement offers. So if you've been injured working offshore, watch my video on what the Jones Act is and how it works, because understanding the basics of maritime law is the first step to protecting your rights. Then watch my video on Jones Act settlement amounts so you'll know if an insurance company is trying to lowball you. And if you want to know if the Jones Act applies to your specific situation, there's a link in the description for a free consultation. We handle thousands of these cases. We've handled them nationwide, and we only get paid if you win, and we'll give you an honest assessment of your rights under the maritime law. Your employer is counting on your ignorance. Don't give them that advantage.